Good morning, all, or good afternoon. I don't know if you can hear me. I can't hear myself real well. Okay. I think I just had my mic turned down. All right. Well, hello everybody, and Bob will be with us any minute. There was a debate over who should run out and who should make the live start. Of course, I wanted it to be him, and then he's like, "No, you do it." And I was like, "Ah." And then I was like, "All right." And then he's like, "Okay, I'll do it." And then I'm like, "Nope, I can do it." So this is me doing it. Yeah. So there you go. There you have it. And Bob suggested that I give the answer to the murder mystery riddle type thing, I guess, or just murder mystery that we threw out there yesterday. I just don't know if many of you here were actually on yesterday, and somebody did get it right last night. I should look to see who that was, so that because I didn't say anything last night, so that more people could have time to figure it out. Um, Vicky's like, "You're doing it." I won't tell Bob our secrets. I will not. All right, let's see who said that. But in any event, so we're gonna start with the sheriff, and we're actually gonna start with the federal lawsuit that has been filed. And we've got the complaint we're gonna go through and some other information, see what we can read through the tea leaves with that. And then I guess Adelson has a hearing today. Bob said it's not too involved of a hearing, so we'll see what that's all about. And um and thanks, Sober Hipster. The Sober Hipster became a YouTube member. Great name. Proud of your sobriety. There you have it. My hats off to you. It's definitely hard to be a sober hipster because, if you're a hipster, you might not have been sober for a while. So it's hard work, hard work. All right, let's see what the person's name was. Okay, so it was Laura Merck 765. At least that's what she is on YouTube. And I didn't really look to see if many of you actually had heard the murder mystery yesterday, but I guess I'm going to give the answer now anyway. So again, it was Laura Merck, 765, and she said that Bob said there was nothing that alerted him to Darren's presence, but the dog would have been barking. Ba-dum-bum-bum. That is the correct answer. She is owed a sticker. Yay. Where's that, yay sound? I hear Bob up there. He's probably just torturing me by not getting on yet. Oh, there he is. There he is. I don't know. There's got to be a yay. No, there's a yay. Hey, babe, we see you down there, or I see you down there. I was trying to find, oh, yeah. Mandy do that, or did Bob do that? Why are you hiding down there?
I was trying to find the hot pocket.
You're the man in Shawshank.
What's up, girl?
Not much.
Get it all started for the kids?
I did. Got it all sorted.
Good job. All right, sorry
Um,
I'm late, y'all. I had to run a very, very important errand. All right. So what did you do? What's going on? We're 2
I've
minutes
done
in.
nothing.
Wow.
I told them the answer. Oh, Lord. Did Mandy do that on your behalf?
Mandy, it's a loop.
Oh, no.
Oh my God.
Jesus, how do we stop it?
We have to. Oh, Jesus. Thank God.
Whew.
Mandy,
I could, oh, Lord.
wow.
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 I could blow up the Hot Pocket and be fine with it. Unless that judge is on, then, like one Hot Pocket will do.
See this face I'm making?
I do.
That's the fuck that
Other
face.
people are like,
I love the
no.
Hot Pockets. And I love Jim Gaffigan. He's hilarious. So, all right. Did you tell the kids what we're going to do? Obviously, we're going to pop in, assuming that it's going to be streamed, which I'm sure it is, with Donna Adelson, see what's going on. He's got a couple of crumb bum new defense attorneys, it sounds like.
Crumb bum, huh?
Well, one of them was a former judge that was rudely escorted off the bench. So I don't know what that means. So sounds like a crumb bum. I don't know.
Sounds like a crumb bum.
Crumb bum. Obviously, I'm gonna keep my eyes peeled for all the updates on the Luigi Mangione case because it's of great interest to me and most of the people in the country.
Say hi to our new member.
Sober hipster. I mean, she's a oldie but a goodie. I mean, she may have re-upped, but she's
re-upped her membership.
She's been fam for a long, long time.
I'll just continue to blame my perimenopause/menopause brain.
I'm a little bit surprised that you brought that up. You're usually very private with your shit.
Well, I mean,
God, I didn't. If I would have brought it up, y'all,
I wouldn't like
there would
that.
have been hell to pay. Not on air. It would have been off air. Allie would have been in that ass. That ass being mine. It would have been.
Well,
brutal.
I mean, our
it is your information to share.
are primarily, women, and there's nothing at all strange or weird about going through menopause. So I actually probably wouldn't have gotten mad at you. So, and
I would never have presumed
it's like
to.
if men are afraid to go in and buy tampons, or girls can't say the word tampons and they get nervous. So I'm trying to break all those walls down right now.
Yeah, you know who has no problem going in and buying a gigantic Costco size bag of tampons or box or whatever? It's me. I don't care. Like what? I mean, if they're either going to think I'm a decent husband or I shove them up my ass, one of the two.
Wow.
I mean, it will only be one of two things, or for one of my daughters.
Yeah.
So. Yeah. And then obviously we want to the first thing, like before we dive into Stines, and that's going to be the bulk of what we do today. I do want to I saw an interesting tweet. So one of the guys, one of the old timers, you had to know. It was a group of like old timers that goes to McDonald's every day is who spotted this guy.
They said it was an employee.
Well, listen, he gives a really short interview. And it's kind of hard to tell. Like his buddy definitely spots Luigi, but whether or not it doesn't sound like his buddy made the call. It sounds like they deferred to the
employee.
Yeah, let me see if I can find it.
What? So you're telling me someone did they not know that there was a reward? Be like, oh, you know what? You get it.
Well, the buddy did, I'm sure. Because he's like, yeah, he had the back jacket, the jacket and the backpack, and it kind of looks like the guy.
I know, but why would they let the employee call?
I don't know, honey. You're asking me questions that I could not, like in a million years, answer. You know what I'm saying?
I'm still like shocked because I think
I found out which guy it is. It's Michael Ruiz. Got the little.
Because I've still been reading that YouTube tried to say that video was only on the imposter thing, and we cleared this up yesterday. You took a screenshot because so what they're saying is the the one YouTube channel was changed to be his name after the fact. So maybe that's their explanation for that, but then why would they Oh, I see. Okay. Well,
What?
because YouTube's denying that channel was associated with the real Luigi. That the person who set up the channel in January changed his screen name on December 9th. Or was that yesterday? Oh, that was yesterday.
Yeah, but no, that like we have in stone evidence.
I know, but what they're saying is that the
I
person who
get it. I get it. That person had created that thing just in case he needed to create a
fake
a spoof account, like
right.
at some point in time. Here's what I'm going to do. I mean, theoretically, it's possible. It's
Yeah.
not a bad idea, actually. Oh, the next big thing that comes up, next guy that I'm going to, I'm going to be ready. I'm going to be the first one to get my thing like up and running. I didn't think it was that easy to change the name, though.
I didn't think so either.
I don't know, though. So, all right, let me pull this up. I was able to find. Sorry, y'all. I'm snacking a banana.
So he says. Mandy had different ideas.
Is that a banana in your tailpipe? What? Okay. So let's see. All right, here we go. Little share city here. Here's this guy. I love this guy.
So
look at that.
He better get the $50,000.
Well, it's not him. It would be his buddy. His buddy's the one who eyeballed him. Ooh. So that's going to be interesting. That's going to be interesting. Like, because I think that is a true debate. Let's hear what the story is. We might have an ad first, sadly.
At least it's for McDonald's.
Wow. Is it?
I don't know. Maybe it's Starbucks. Oh, that's neither. Okay.
Yeah.
It's definitely coffee of some sort. Oh, it's for...
Wow.
What? I don't even know what that means.
Me either. I mean, it's clearly for the area.
Oh, I didn't really see a whole lot. I mean, a group of us are here every day. And one of my friends, and I thought he was kidding. When the shooter, I'm assuming was the shooter who they made the arrest on, came in, he made a comment, "Well, that looks like the shooter from New York." But I thought he was, the group of us, I thought it was more of a joke. And we were kidding about it. But then as it turned out, it was him.
So he kept it to himself.
Like I said, the employee that thought it was him that I guess started the initial investigation on it. I talked to her later. I said, "Was I here when he came in?" And she goes, "Yeah." And she goes, "Actually, you and your friends and all were making a joke, almost like saying, and that's pretty much about it." I mean, he ordered, went to the rear of the store.
There's an asterisk right there.
I passed him whenever I left. I left and went to church, come back, because I heard there was an arrest. I didn't know which McDonald's it was, but it was this, where we were at. I think I looked at the guy, but his back was to me. He did have a backpack, but my friend Mike that said this, I asked him again this morning. I said, "Were you kidding or not?" He said, "No, I was serious." He goes, "The backpack, the jacket resembled the one he said the day of the shooting." There was no reaction from him whenever my friend said that. And the worker, if she heard us talking, he had to have heard.
That's what I was wondering, where they were sitting.
That's what I said yesterday.
Somebody told me he was here this morning. They think a couple days. I don't know if that's true in Altoona. And I'm anxious to see more that comes out to see if that is true. But I don't know. I know it was raining pretty good yesterday morning, and I was surprised he stayed here as long as he did. You know what I mean? Being on the run or whatever, you know. That sort of shocked me.
I mean,
So
could you love that guy any more than you do,
I
though?
could not. He is so
Or-
exactly what EB said. He is so adorable.
yeah.
I went to
He's-
say how adorable he was, and then I saw that little comment down there.
Yeah. Has anybody seen like the whole crew? Like, have there been interviews with the whole crew of like the McDonald's Old Guys Club? Because I mean, that's definitely going to be me. I'm going to have the McDonald's Old Guys Club. Hey, I'll be over there at 6:30. We'll all get our cups of coffee, just talking about life every single day.
At the McDonald's.
Yeah, honey, you're
That
gonna
you
be
never eat McDonald's.
I never eat McDonald's, and you're gonna be my everyday morning breakfast partner. Not some.
Yay.
Yeah, come on, dude. I mean, that would have to get boring. I mean, what do these guys talk about every single day?
I don't know, and I get a little pissed off when you're
Apparently,
like 80 still saying it's just the guys.
hey, listen,
No one else is bringing their wife.
no one else is gonna have their wife there. So, all right. So, I mean, that seems to substantiate the fact that he knew, or at least, at the very least, somewhat corroborates my thought that the kid knew. Like he knew, like, because remember, I was
What do you
going
mean? He
to
was shaking when they asked him. Shaking.
wait, what?
When they asked him if he was in New York, he was shaking in horror. He didn't believe that they.
Babe, we're
kidding.
talking about two completely
No,
different.
you are that you're talking about how he was wanting or expecting to get caught. So I'm
Right.
saying how they were like, oh, he was shaking, like, oh my God, they got me when they mentioned New York, like dumbfounded.
I
You
I
know who
think-
I am?
I think the enormity of the situation, once it kind of actually becomes reality, may have caused the shaking,
That's
right?
true.
I mean, it's like
If
one
he
thing
was
in
in
your-
fact shaking.
if he was, in fact, quivering with fear.
Right.
Oh no! Oh, I don't
But
know.
I did hear this Spitfire, and I kind of have some thoughts. First of all, someone tell me, because I'm missing something. What was the point of the bag being waterproof? Like, why is that significant?
Raining. It
No,
was raining. It was raining men. Well, they say it was a Faraday bag, so you know what a Faraday bag is.
yeah, that to block
Yeah.
signals.
Right. So
Oh,
I
so
mean,
he's saying it
that's
was waterproof, not a Faraday bag. So it wasn't necessarily important that it was waterproof. It was just that it wasn't a Faraday bag. All right. So this whole
no.
8,000.
I think I almost strained a muscle in my neck doing that move. Not doing it.
Wow. But wait, let me say what I was going to say about the $8,000. So, I just don't know, like, who in Altoona is planning $8,000 in his bag, and did the police come from New York with money to plan on him? What would be the purpose? I wonder if he has some sort of plan for why he would say that they planted it on him. Can you think of why they would plant it on him? What would be the point of that, and why would that be like an advanced thought for someone to come up with $8,000 to plant on him?
Well, just to make it seem like he was a guy on the run with cash. I mean, that definitely is. Wait, you're making that face. Like if you've got a guy who's planned out every step of something, like obviously he can't be accessing ATMs, right?
Right.
So he has to have the cash in advance. That would be a very good thing to plant to show indicia of guilt, right?
Well, right, but he didn't say I didn't do it. He's just said that wasn't my $8,000. So
I don't think he said I did do it either. I mean, look,
know.
we're all jumping to conclusions with the manifesto. And for the record, what I've seen is the manifesto is 236 words. So that's not your typical manifesto. That's more like a short note. But like and until I see it with my own eyes, I got to take the words of what law enforcement's saying, which, as you guys all know, take it or leave it with whether I believe what they're saying. So, I mean, we'll see it at some point. I hope somebody's going to leak it like that. We could be rest assured. Some copper is going to leak that thing. That thing will make its way out to the public. and we'll see what it says. I mean, because it's like he alludes to doing it. If we're to believe what he's saying, what the cop is saying, it said, right? Like he's like, well, I had to do it.
Right. It was
No,
me alone. I acted alone.
I acted alone, all that kind of stuff. So
Had to be done. And I'm sure everyone's seeing that they're reporting about his back injury, which I think is the same thing somebody mentioned yesterday that we highlighted um, in the chat, that he had some sort of spinal injury or something.
yeah,
But they had his in Hawaii. He applied and I think was accepted right into a co-living um, complex apartment group of apartments. I'm not exactly sure for $2,000 a month, and it was like-minded people who want to give back to the world. Da 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 da. Da. And they said that he had complained about needing a different mattress and told somebody that he couldn't be intimate because of it would be too painful. So there was some of that out there. We'll have to see.
well, yeah, and it's come out that his family's loaded.
Well, we
So
don't know that as fact.
I think we do. We know it is fact. His family's wealthy. His family's very wealthy. Old Gwen yesterday was giving us the business, but then I mean, I hope she was writing strongly worded letters to the New York Times and everybody else about posting about his family having lots of money. No, his grandfather, the original Mangione over to the United States, made a buttload of money in real estate,
You
nursing
mean mafia?
homes.
I mean, isn't that what all the Italians did when they got over? I thought.
I have never been more insulted in my entire life.
Uh,
That's the first thing I said. I'm like, oh, I'm great. I'm like, great. Luigi Mangione. You can't get a more Italian name than Luigi Mangione. As soon as I saw his name, what was I doing at the house, babe? Do you even remember?
I mean, you're
I
you're
was
speaking with an
upstairs.
Italian accent.
I was upstairs and I yelled down to you. I'm like, they got the guy's name. I'm like, it's Luigi Mangione.
Yeah, that is what you were doing.
That's what and then I said, I'm like, look, I'm like, oh my God, this guy's setting the Italian Americans back 150 years, 150, like all the advancements we need to get over that horrible thing that you just said about
Mermaid. Oh, I'm sorry. Somebody went to just highlight something, and I clicked on this. Is this true? Does anybody know? Mermaid says, "Did you notice he peed his pants?"
I saw I posted the picture on
Oh,
Twitter. Here, I'll pull it up. And then I
no,
want to look.
that's all right. Let's just go to the.
I don't know if he pissed his pants because it's weird. It's like it's not in the area unless his pee-pee was facing upwards. Because it's like all the pee
Yeah, he
is
didn't
up.
shake well. It's a P dot.
No. This is no P dot.
Oh,
Like if he pissed his pants, it's either the way that the jeans look. The ironic thing is that picture, he's literally standing right in front of a steel toilet. You could see it in between his legs. So, but I could see the cops being like, yeah, no, we're not going to let you piss, dude. Just piss your pants there, chief. I mean, that's kind of shit cops do. So, I mean, like, it wouldn't surprise me.
I'm with McNeil Shadow, but I haven't even seen it. So,
All right. So, overnight, he was officially charged in New York State. They put out the felony arrest warrant. Obviously, he was already in custody at that point. So he has been charged with murder in the second degree. And just so you guys know, I saw a couple comments yesterday. There is no death penalty in New York State. So that is not on the table. Not now, not ever. Well, unless they change their mind at some point down the road. So he's got one charge of murder in the second degree, which Allie and I were both kind of wondering what made
I'm
it
going to
second
pull up
degree
the
there.
statute. That probably was where my answer was all along.
That was my cue to you to do exactly that. And then the second charge, he has two charges for criminal possession of a weapon in the second degree. And then he's got the criminal possession of the forged instrument in the second degree, which is the fake ID. And 5, the criminal possession of a weapon in the third degree, which is the silencer, I believe. So we'll read through it real quick. And I promise we're getting to Stines for all the, like, we have to talk about this. Like, it would be it would be terrible if we came on alive and did not talk about this. It would be irresponsible. So on or about December 4th of 6:44 at 6:44 a.m. outside 1335 Avenue of the Americas in the county in the state of New York, the defendant with intent to cause the death of another person caused the death of such person. The defendant possessed a loaded firearm with intent to use it unlawfully against another. I'm assuming that that's what the statute says. The defendant possessed a loaded firearm outside of his home and place of business. The defendant uttered and possessed a forged instrument of a kind specified in 170.10 of the penal law and particularized below with knowledge that the instrument was forged and with the intent to defraud, deceive, and injure another. The defendant possessed a firearm silencer. All right, hold on. Hold on. Gotta do what I do. Gotta get my scrolling enabled. Why isn't it? There has to be a way I can set it as default. Like, I don't understand why everybody doesn't always want it scrolling. That seems bizarre to me. The factual basis for these charges are as follows. I have reviewed surveillance video depicting the exterior of the Hilton at the above location, specifically a camera angle depicting 54th Street between 7th Avenue and the Avenue of the Americas. In the surveillance footage at approximately 6:44 a.m., a man wearing a distinctive clothing outfit, he was wearing jeans and a jacket. Wasn't distinctive. Do you think that was distinctive?
No.
No. Approached Brian Thompson from behind, and the shooter held what I recognized to be a firearm with the silencer attached to the end and fired it several times at Brian Thompson, causing him to collapse on the ground. I am informed by Detective Oscar Diaz, shield number 4656 of the Manhattan South Homicide Squad, that he was present for the autopsy of Brian Thompson and that the cause of Mr. Thompson's death was determined to be a gunshot wound to the torso. The defendant is the person shooting and killing Brian Thompson. The above described surveillance footage based upon evidence collected during the investigation. It's a very definitive statement there. But not limited, including but not limited to I, Roman numeral I. Surveillance footage that I've reviewed from the Hilton, New York City. Oh, the HI New York City hostel at 891 in Amsterdam, which depicts the same man wearing the same clothing, leaving the hostel at December 4th, 2024 at about 5:34 a.m. 2, surveillance footage that I have reviewed from the same hostel that depicts the same man checking into the hostel on November 4th of 2024 at about 11:20 p.m. and showing a driver's license upon check-in. 3, I have reviewed business records from the hostel that showed the man provided in New Jersey's driver's license with the name of Mark Rosario on it. I am informed by Detective Diaz that he is informed by Patrolman Tyler Fry, badge 351 of the Altoona Police Department, that on December 9th of 2024 at 9:58 a.m., defendant was taken into custody at the McDonald's in Altoona, Pennsylvania. The defendant presented a forged New Jersey driver's license with the name of Mark Rosario as his identification, which based on the number on it was the same identification the defendant presented at the hostel. And that in the defendant's belongings, Patrolman Christy Wasser, badge 250, found a semi-automatic pistol with what appears to be a 3D printed loaded receiver with a metal slide and silencer. Now, we read that the silencer was made on the 3D printer too.
Yep.
It's crazy. And written admissions about the crime. So there's your manifesto. That's it. So, as you can see, I tweeted this morning because I thought it was odd. Just to me, the whole thing is odd. He's on the run for 5 days. Is it possible that he's just like, I can't, this is not something I'm not going to be able to maintain for very long. The whole world's looking for me. I'm just going to kind of keep going to McDonald's or fast food spots until somebody recognize. You can see Allison reading feverishly and not listening to a word I'm saying. See, the problem is I'm trying to talk to you. So I'll wait.
Well, I was trying to figure out if, because New York has a very interesting first-degree murder statute in that it has to fall into these very specific categories. And the only one that I thought might be relevant or might work is that this was during an act of terrorism. So I was looking up their definition of the act of terrorism, which I think this would fall into because it's like to intimidate or coerce a civilian population, to influence the policy of a government, or by intimidation or coercion. And again, it also deals with the civilian population, but then it gets to this specific offense. So if for the purposes of this article, act of terrorism means an act or acts constituting a specific offense as defined below, or an act or acts constituting an offense in any other jurisdiction within or outside containing, that is intended to. So they have to be committing the specific offense that is intended to intimidate or coerce a civilian population. So I'll have to do some more research, but it might actually not fit in that because they don't even have first degree murder as one of the specific offenses. They've got manslaughter in the second degree, bizarre, but they also have unlawful possession of personal identification information. So he did have that. But yeah, the first, to be convicted of first degree murder, there's a litany of things, including like the victim was a police officer or a fireman, an employee of the state corrections, that you were in the state correction institute when you did it. The victim was a witness to a crime you already committed. The defendant was hired someone to kill someone pursuant to an agreement in exchange for money. They were killed in the course of committing a robbery, a burglary, a kidnapping. They were trying to get away, not be caught for another crime. So the only one that works is, or they'd been convicted of murder before that. It's especially cruel and wanton, which they define as involving literal physical torture. And the other one is the victim was killed in furtherance of an act of terrorism.
Is that's under one?
That's under one. Yeah. So none of them.
I'd be shocked if they didn't consider this to be domestic terrorism. Shocked.
That's what I thought, but I just can't tell, and I'll have to do a little more research after this if this technically falls in. Because at first I was thinking, you know what, they don't want to have to deal with the whole, why make the healthcare system even more of a part of the offense, because that's basically what you would have to do to meet this, like that you're trying to influence or intimidate or coerce a civilian population, that population being people in the healthcare industry. But so my initial thought was, well, you know what, maybe New York doesn't want to make the case any more about the healthcare industry than it already has to be. But now I'm just not sure that it might not technically fall into their statute for terrorism, because the offense has to be committed in furtherance of one of those specific offenses. So I wouldn't say that the murder was in furtherance of identification, fraud. I don't know. I'll have to look at it because I think it should. I think it does seem like it would fit there, and I think that would be the answer. Is like, well, why make it even more about, more about the healthcare industry than we have to? Like, that's just making it even more the sort of focal point.
Right. I mean, because like I tweeted it, you kind of rejected it offhand yesterday. The concept of potential jury nullification. I don't Honestly, I don't think it's that far of a stretch, honey. I really don't. I think that there are a huge amount of people that have this guy as like kind of an anti-hero.
Oh, you know what I love, by the way, is their first degree murder requires um, that the defendant be 18 years of age or older.
Okay, so me too. So, but I wanted to have the conversation that you just like completely.
I just think that at the end of the day, all right, the other
Let's have
thing
it out. Let's
like,
have it out.
I'm gonna say this, I think, and we've kinda talked about this before, that when you're selected as a juror and you're in the trappings of the court, and you take your role very, very seriously. So I think for that reason, they're not gonna be easily swayed, like, to be back there arguing amongst each other like, "So what?" You know how many people they denied coverage to that were killed? I'm finding him guilty anyway. I don't care. Like I honestly, I mean, not guilty. Sorry, because he only killed the CEO of a healthcare company who's killed thousands. I don't think that they will do that when it comes down to it in the jury room, in deliberations, with the trappings of the court.
All it takes is one.
That's true.
All it takes is one. And I'm just telling you, this isn't like every case. Like typically, I 100% agree with you. Like people when they get into that courtroom, when they get into that trial, they understand the weight of it. They feel it. They feel it. Oh, Brooklyn. Which way would you go, Brooklyn girl? So
We're ignoring the presumption of innocence for this episode and this episode only.
I'm not ignoring it. I'm talking. This is just a hypothetical situation that we're talking about. Like of
All right, hypothetically, if this is the guy, how would
If-
you
right. If this is, I mean, look, do we need to? Our channel is called Defense Diaries. If people don't understand that we are very big on the presumption of innocence in the Constitution at this point in time, you're not really watching the content. I mean, I couldn't be any more clear, and Allison could not be any more clear about our positions on that. I feel that we don't have to constantly restate it, but maybe we do. Maybe
I
we
was
have
just kidding because we're, like, asking her to say what her verdict would be when, like, she doesn't know any of the facts. So, yes, it's definitely a hypothetically, this is the guy.
right.
Would you
Hypothetically,
nullify? Would you
well,
nullify?
allegedly is the guy, and I mean, those eyebrows don't seem to match in that picture. That's the one thing
That
I'll say.
gets me. It gets me.
It bugs
Something
me.
about those eyebrows.
I think the easier answer to that is that law enforcement kind of got like a little overzealous in putting pictures out, and maybe just maybe a couple of those photos weren't actually him. Like the ones at the hostel, fine, but like other ones, maybe that because like I forget who it was. Somebody was tweeting me last night. Have you guys ever seen Dave Franco? I'm pulling a picture of this fucking guy. Oh man. I'm like, you mean James Franco? Because I'm old and I don't understand this modern world or who the hell Dave Franco is. But
Is he like a person in the public
he's James
sphere?
Franco's brother, the actor.
Oh.
Wait till you see this shit. It's fucking crazy.
Akasha said that's who it was, Bob.
Wait, what does that mean?
I think maybe she's saying that's the picture. Oh, she couldn't remember his name. She was trying to remember his name. Something she said earlier. I thought she was saying they accidentally got a picture of Franco.
Hey, look, I love Akasha, but how the hell would she know? All right, let me see. All right, what's going on here? All right, something froze up over there. My shit's not working. What's going on? Uh-oh, I have some kind of freezing situation happening.
What's the guy's name? I'll do it.
Dave Franco. I'm gonna leave out, come back in. There's something weird going on, and I think like I can't move.
All right, we don't need you.
Okay.
Oh, this guy's even much more handsome. All right. Oh,
Well,
someone has them up together here.
He's got his hair cut.
Right next to his picture is a picture of
Luigi.
Yeah. Hold on. It's a coming.
Oh wow. He just keeps firing with the anti-Italian.
There you go.
Like, that's not even a good match with him. Like, there's pictures, like the pictures from his Facebook. All right, this is super weird. Like, nothing's working. Like, I can't
Sorry. What can I
even
do
leave
for
the
you?
studio.
I'll say Dave Franco's a very handsome man. Tell you that much.
He's the brother of
This looks like his brother.
James Franco.
Is that the brother? Is that James Franco? Or is
No.
that that's also Dave?
I would argue that he's actually more handsome than his brother.
Yeah. Not more
Kind of like
handsome
in
than my
a
man,
kind of
but
like in a traditional Hollywood type of,
were you
kind of.
leaving us to go do
Honey, are you not hearing me? Like, my computer's frozen. I can't even click. Like,
Oh.
nothing's happening. Like, I don't know what's going on.
Can I kick you
Weird.
out of the I started this thing, I should be able to kick you out. He's like, "Out. He's gone."
Yeah, take me off
So
and
then you wouldn't be able to get back in if you're that frozen. We need you.
but I can't do I can't even scroll through the chat is what I'm
Well, I
saying.
don't know.
It's
Can
being
I
really
actually
weird.
boot you?
I
mean,
can't hit any of the like, none.
oh, he's gone. I think Mandy did that, but that's not what you wanted. You wanted us to actually
All right, I think I'm gonna have to reboot. So
All right.
you guys, this won't kill the stream though, right?
No, I started it.
Okay.
We don't need you.
All right.
Bye.
Yeah, I'm gonna have to hard reboot here.
Bye, Felicia.
Bye, Felicia.
All right. Well, there you have it. There you have it. We'll thank some people. We're waiting for Bob. Ariel became a new member. Thank you. Miss K, you're the greatest. Dom's mom gifting 5 memberships. As Bob would say, an always giver. Sooner Gal 22, I want to talk about perimenopause. I'm mad at my doctor because they say I can't be having hot flashes. I'm like, really? Come over here and experience this with me. Why don't you? That what does that mean? Why would they be saying such a thing? Um, oh, are they saying you don't get them during no, because my friend that gets them has not technically to be in menopause per the actual definition, you have to have not gotten your period for 12 months. And my friend that's been having her hot flashes hasn't gone 12 months. So I'm with you sooner. You need new doctors. Thanks, Donna. Lindsay says, so we have backpack misdirection. There was different backpacks on the pictures too. It's all weird. Girl Ryan. All right, Girl Ryan. Thank you. Why is no one shut up, Chrissy? Why is no one talking about how he was held in prison and not being allowed an attorney? Who are we talking about? Is Luigi being held in prison and not being allowed an attorney? This was from 1241. She just posted that. Is that what's happening? See, I need Bob he's to be he knows more. He knows the things. Yes, I was joking that, is it Koberger? Because that the eyebrows. There he is.
All right. That worked.
Babe,
That was
people are
weird.
saying that he's in prison already, not in jail, and he's being denied a lawyer.
Well, it is being reported. Remember, he's getting extradited, y'all. So
Why would they hold him
he
in a
is
prison
still.
to extradite him, though?
I think that they wanted to keep him somewhere safe overnight, and I guess they're guessing a prison or, it's the
A
Richard Allen
single
treatment.
cell? I mean, you can literally hold someone at the jail in a cell.
Did you turn your mic down?
No.
Oh, all right. You sound lower than you did before. Maybe you were sitting back. I did hear that he's in a cell in Pennsylvania, but
You mean a prison in Pennsylvania?
yeah, a prison in Pennsylvania. But he's going to be getting extradited. I think he's probably going to be due up in court today if he hasn't already gone in.
Well, this is what this Lori just said. Are we missing things? He just screamed out to a crowd going into court, "This is unjust."
Wow. All right. He's had a night to think about it in custody. So the game is afoot, my friends. The game is afoot.
Hmm.
That's like what's his face who killed Lincoln, screaming out death to tyrants before he, assassinated poor old Abe. Mandy, yes. What did you send? All I saw was an email. Let me see. I just saw the email with the counts. Did you send something more recently? Let me see. Mail.
Hmm. I don't see anything. Um,
All right, let's see. Okay, Mandy's sending stuff. Mandy, the last thing I got was 1121 from you, and it's got the warrant. I don't have anything else from you, Mandy. From today. I got the Stein thumbnail, and that's it.
oh Lord. Mandy's really she's picking gems to highlight all the people saying he's handsome, offering their services.
Their services.
Brian.
I told you, man. What I'm trying to tell you is I have my finger on the pulse of the people far more than you do via social media.
I mean, it's
And
easy to joke around about it,
I'm
but
not
I
even
still don't
joking
think people are
around.
gonna do it in the courtroom.
Well, I think there's people that have strong feelings about it. So, I mean, it's hard to know. I mean, it's interesting. So, and I mean, this thing's going to play itself out, but I don't know how the fact that he comes from money, how that is going to jive with the people that he's the Robin Hood or he's an anti-hero. I don't know how that really kind of jives with that concept that he's like a man of the people when it sounds like he was wealthy and spoiled. So, maybe this is going to be another affluenza defense.
So it's worth noting that his family reported him missing some time ago, but didn't, as far as we know, report that they recognized him in those pictures. And clearly, if he had been missing for several weeks leading up to this, they definitely, were like, "Oh, that's my son."
So Tina, Lucille, I love this question. Thank you very much for asking it. We are two defense attorneys. If you're new to this channel, so we got a nice crowd here today. So we love questions like this. So no, they did not get a
I
search
thought they
warrant.
did say they got a warrant.
Okay, can I
Go
finish?
ahead. Yes.
Okay, so no, they did not. I read through the warrant last night. Remember? So
I
no,
do.
it was a search, what they call a search incident to arrest. It was an inventory search after he was taken into custody. Then they looked through the backpack in order to take
Inventory.
inventory. Defense lawyers love inventory searches. They're our favorite things. It's like it's a workaround. It's a workaround for getting a warrant right away. I mean, I think careful cops like to get the warrant before they do it, but the Supreme Court said that inventory searches are okay. So that's when they found the stuff during the inventory search after he was placed under arrest for charges not related to the New York thing yet. So remember, he was arrested for possession of a firearm, I think, and possession of forged documents in Pennsylvania. Those are the charges. They will, of course, dump those charges if they haven't already. But they will. They will. So yeah. All right. I forgot what I was gonna do. Wait, what was I gonna do? Um, from what I heard, he gave up his shit, including the gun, so there won't be a problem with the search warrant. Yeah, I mean, like the search warrant in and of itself, Veronica isn't going to matter because the search was done incident to arrest in Pennsylvania. Now, does that mean that his lawyers won't attack it during pretrial motions? Yeah, I'm sure they will. You know, I mean, because obviously, like at that point, he had already given the ID. I think he gave the fake ID, or he alluded to that was his name. And then but like, how would they have known that he had the gun? You know what I mean? Prior to.
Hmm.
So I don't know. It'll be litigated, but the search was definitely done a search incident to arrest. Okay. Oh yeah, we definitely want to. If anybody can link in the video of him screaming, I definitely want to see that.
So here's a New York case because I was trying to see, New York is one of those states that, you've got to take the entire bar because they've got different laws. They don't follow they've got some of their own stuff here. So in 2016, this case says that although the search of the defendant's backpack was not justified as a search incident to arrest or as an inventory search, any error in receiving the items recovered from the backpack was harmless.
Hmm.
And this is New York Supreme Court is not their highest court, so this is their appellate court. Was a suppression hearing. Doesn't even give any of the facts. At a suppression hearing, he was convicted of burglary in the second degree, violent felony offender. The verdict was based on legally sufficient evidence. It was not against the weight. There was no basis for disturbing it. I mean, it doesn't really say anything other than that one sentence. Bizarre.
So Travis is most states do not appoint an attorney to a person arrested on a state warrant. New York has 30 days to give governor's warrants under the governor of Pennsylvania. So I mean, like, what we don't know at this point is whether or not he's going to waive extradition. Okay, so like I don't know what happened in court. Per usual, I'm having a hard time finding anything. I'm not seeing anything. I'm on the YouTubes looking for. I use the quote, "This is unjust," and Luigi Mangione, and I'm not finding anything. So I'm sure somebody will find it.
Right. So and Pennsylvania is going to be different than New York as well. So that's why I was sort of interested to see if New York had a different, like a different rule, because New York is saying you can't. This case from 2006 is saying that you can't search a bag at the precinct as incident to a lawful arrest. And they go on to say that the state never asked any questions about an inventory search or never argued it was an inventory search.
Wait, are you looking up New York law?
Yeah.
Well, that happened in Pennsylvania.
I know it did, but I wanted to see, because if New York had something that Pennsylvania didn't, it might be like, all right, you guys do this here. You know what I mean?
Yeah, definitely.
Because you can still use it in,
We're gonna have to get real familiar with the like New York stations so that we can, like, they're gonna be the ones that are gonna catch all this shit. Or I just have to be combing through my Twitter. Twitter is the absolute best way to get news for me personally. Like, I put out more news quickly and I get more news quickly on Twitter than anywhere else on the planet. That's for sure. Okay. Let me see. I'm gonna go. I want to pull up I want to see, hold on, I gotta find. Babe, are you checking the chat? Make sure, like, usually there's somebody me see here. All right, so I'm gonna go to what the hell? Okay, I'm gonna go. All right, so here's what we're gonna do right now, and we'll like as things go on with. Oh, hold on.
Wow. I've never seen opinions like this. New York. It's just wild. They don't give any of the facts. They just give the ruling. It's like a slip opinion. Hmm.
Okay, here we go. I found it. Actually, Mandy found it, and she had to call me. All right. Okay, so this is gonna be it. This is the video. So we can see it's 1:37 Eastern Standard. So his extradition hearing is going to be imminent. Yeah, Sapper, we're switching over to Mickey Stines.
All right, guys, what's happening?
Oh, no. Nice camera work, Jerkoff.
It's completely out of touch. And it's an insult to the intelligence of the American people and its lived experience.
Oh man.
I missed the whole thing because I was reading case law.
Well, now this video knows how I feel. Okay.
It's completely out of touch.
Okay, we'll hit.
It's completely out of touch. And it's an insult to the intelligence of the American people and its lived experience.
Wonder what else he said there.
Free Richard Allen, I think I heard him say. Kidding. Everyone calm down. All right, so that's interesting. Is there anything else worth watching on there, Mandy? Or is that kind of it?
I think the people want us to switch to what
We're switching to
thumbnail says it is.
Yep.
You should probably post something about the American people. You should probably post a comment on your YouTube channel.
Machine? What do you
or
mean?
the Twitter machine, yeah. Like your YouTube channel that says we are now shifting
No, we
gears
didn't.
to-
We've got 900 people in here. If we lost 12 people, well, what are you going to do? Like, this is kind of breaking news.
No, it is. I'm definitely interested to hear about it.
Okay, well, good, because they
I'm
did.
not-
I'm not sweating it. Steins isn't going anywhere.
Nope.
All right, so let me see. All right, so I want to start with I'm going to start with this thing that dropped. So when we were going to do Steins on Friday.
Ah.
Okay.
Cammy Q says this is completely unjust and an insult to the intelligence of the American people.
Wow.
Sounded about right. Thanks, Cammy Q.
Did sound about right. Okay. Okay, so let's see. I've got to try to figure out what
If
was
you
Friday. What was Friday the 5th?
I think maybe the 6th. No, let me see. Yeah, Friday was the 6th.
Friday was the 6th. Okay. Babe, what are you doing? When I'm typing things, you have to talk. You can't sit
Okay.
there and just read.
All right, so I'm assuming what we're about to talk about is the federal lawsuit.
Well, yeah, so we're gonna pivot right now over to the Kentucky case, Lecter County, of Mickey Stines, who stands accused of shooting Judge Kevin Mullins to death in his chambers. I think he shot him 7 or 8 times. I became fascinated with this case when we watched the preliminary hearing back a couple of months ago. And it seemed like there was some odd facts out there about this case that really piqued my interest, namely that either a phone call to his daughter, and his being Mickey Stein's daughter, was made from the judge's cell phone, and or his daughter's number was stored in his cell phone.
Haven't we since learned that doesn't seem to have actually
No,
panned
we
itself
heard an
out?
opinion from someone that maybe. We did not hear anything definitive, because after we had that phone call late last week, I've seen his lawyer, Mickey Stein's lawyer, who you were supposed to be trying to reach out to, by the way, hint, hint, nudge, nudge, had said very much the opposite. So it's yet to be determined is where we're at. So and I don't want to hear it. I don't want to hear it. I'm gonna pull up a News Nation clip from Banfield.
Oof. And we're gonna say that we do not endorse. We're
Hey,
just
I've been on Banfield.
I know, but I'm
Granted,
just
it's always
saying,
about my
we're not
Daisy.
saying it's definitely factual
Right.
because
Well, this is what we're going to say. Give it the weight that you deem appropriate. And the reason that we're showing this is because we're going to be dovetailing directly into the federal complaint. It's a civil complaint against Mickey Stines, who was the elected sheriff, and one of his sheriff deputies.
it's primarily against Ben Fields in his
Ben Fields, right.
individual capacity and in his capacity as the deputy sheriff with the Letcher County Sheriff's Department. And then also named as defendants is Mickey Stines as the Letcher County Sheriff. So he's not named individually, which gives you some insight into that they're not going to be alleging that he personally engaged in the similar behavior as Ben Fields. And then also the Eastern Kentucky Correctional Services.
Right. Okay. So here we go. So trigger warning. One of the first things they're going to show is this Judge Kevin Mullins getting gunned down in his chambers. So that kind of thing is not your kind of thing. If you don't want to see that, I'm warning you now. It's going to be one of the first images they show on this piece here. So maybe you want to check out for a minute and then pop back in.
Judge Kevin Mullins right there in his
You
own
hear it?
chambers. We know who fired those shots. It was on video right there. That was Sean Mickey Stines right there with the gun. He was the sheriff at that time of their rural Kentucky county.
That's
And
much
he was
better
also a
video
close
than I've ever
friend of the
seen.
judge. And he's not a sheriff anymore. He's an inmate waiting for trial. But just like the CEO murder, the motive in the Judge Mullins case is a mystery, which means that the two men's long shared history has been under the microscope. And tonight, a gut punch of an exclusive to tell you about. It turns out there are recordings about the dead judge that tie him to some very dirty business in that county. A sex for favors scandal that sent a former deputy to jail and got the sheriff, who's now facing murder, sued in federal court. News Nation investigative producer Allison Weiner uncovered these recordings, and she joins me live now. You're such a great producer. I mean, we send you out to dig this stuff up, and then I have to have you on television to report it. What kind of a reporting are we talking about, Allison?
Well, these are recordings from the criminal investigation into Deputy Fields, the guy that went to prison for the sex for favor scandal. And Deputy Fields was convicted of rape 3, of sodomy, and also of perjury. So the recordings are from his victim. And she subsequently has filed the civil rights lawsuit in federal court. The victim is Sabrina Atkins, and she was interviewed by police about what had happened to her when she was an inmate in Fletcher County in Whitesburg.
All right. So right from the get, we know that these are self-serving statements because this is the statements of the plaintiff in the civil suit, one of the two plaintiffs in the civil suit.
I have to say that it is my understanding, based on good authority, that the producer is misunderstanding what she heard, and what Sabrina Atkins was speaking about was not what she.
All right.
was
Well,
not
we're going to hear the actual recordings.
Okay.
And that's where Sheriff Stein was working, and also where Ben Fields was working. And these recordings, I was listening to them, and I just sort of stopped and was like, I'm beginning to see that Sheriff Stein's life was coming apart, like sort of one thing, one block at a time. And this was not a good thing that I was listening to. And let's take a listen to it, and then we can talk about it.
He does have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls sexual and stuff.
What describe? Have you seen the video?
I've seen one partly, just him having sex with girls for to be able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
With the judge and.
You saw the video?
Yeah.
Okay. So you still want to maintain that she's misunderstanding what she heard?
I don't know. There's some discrepancy about whether
I don't think
she
there's any
actually
discrepancy.
saw evidence of the judge. There's not in the audio we're listening to right here, but in information I received on good authority
All
that
right.
it does not. It does not. I don't know that she actually saw this judge having. I mean, maybe he was having sex in his chambers. I don't know. I'm just saying.
Right.
This is not confirmed.
This is alleged, like everything else.
Right. And there's reason to think there might be inaccuracies in this reporting.
Well, I mean, it's not so much the reporting. There may be inaccuracies in what Sabrina Atkins is saying.
Or the way she's saying it, because it was Ben Steins and higher ups. So
Wait, Ben Fields.
Ben Fields.
Ben
Sorry.
Stein. Wow.
Sorry. Jeez. Ben Fields and higher ups. But go ahead, keep playing it.
All right, I rewound it so you could hear it again. I mean, to me, I don't, the reporting is what it is. Like, she got this recording,
Right.
and it's definitely this plaintiff in the suit saying this.
Sex with girls for to be able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
With the judge and.
You saw the video?
Yeah.
What did you see on the video? I mean,
I've seen Judge Mullins having sex with a girl.
Who was the girl?
I don't know. Because I don't know a lot of people from over
Where was it at?
in his office, in the judge's chambers.
Is that the same place that you were meeting Ben? Is that how you know it was a judge in chambers? And this was Judge who?
Mullins.
Allison, wow.
That's the same face I made. I mean, it's
Right.
like-
I think that it may have been she thought that. It may have been he was having sex in his chambers, but there is no witness that has come forward, despite investigation, that Judge Mullins that they had sex with Judge Mullins as a part of any of this.
Okay, so I think that's the only recording from that clip. All right, so let's pivot over to the.
And he's not named as a um well, he wouldn't be because she didn't. Okay, so never mind. I take that part back.
Okay.
I've got the second amended complaint up if that's what you want.
Yeah,
But
pull it.
You're
pull it
going to
up.
read it, right? Because it's easier for you when you read it.
Oh yeah, you know what? I'll just pull it up from my. That's the one you want me to do, right? The
Yeah,
second
it's
amended?
saved as the number 2, second amended. It'll pop up on your
Okay.
computer. The first complaint didn't have the Eastern Kentucky Correctional Services in it, so this is going to be the same thing, but with additional allegations against them.
Okay. Let's see. Sorry, I had it pulled up, but when I had to reset my computer, it shut down my Adobe. So,
I think that the sound is the interview of Sabrina Atkins. I do believe that is.
that is 100%
Yeah.
Sabrina Atkins in that interview. There's no question about that. The question is, as I was starting to say, was whether or not that's just some self-serving statement because she's got a federal civil lawsuit going on.
Well, or that she saw a judge, was told it was him, or it was him having sex, but not necessarily with a girl to get out of.
Babe, send it to me again. Like, I don't know where the hell it's at.
So did you click?
No, I typed your name in, and it's like
No,
it's
no, no. It's stored in Dropbox.
Oh,
So hit
okay.
Command in the space bar.
Yeah.
Type in.
Okay, I'll just go right to my Dropbox. Okay. All right.
Shift it to whatever you always need to change it to scroll.
Thanks, babe.
You're welcome.
All right. Okay. All right. I'm gonna pull it up. Okay.
So, babe, you're saying you saw something with his lawyer indicating that the daughter's number was actually stored in the phone, because the information we received was that he just dialed the daughter's number from the judge's phone, and she answered the judge's call but wouldn't answer her father's call.
Like, that's where the story was a little confusing. Like,
That's
so
my understanding.
right. So we've heard that maybe the defense attorney during the preliminary hearing was overselling that and or misunderstood what was going on in chambers that day. So one of those two things. So
From what we understand is that the dad tried to call the daughter. She did not answer his phone call. Then he dialed the phone number from the judge's phone, and she answered the call. And the purpose of that was to see if she would answer.
were you on when I did that? Were you on when I did that? That live?
I mean, initially, yeah.
With the preliminary hearing?
I either watched it or I was on. I can't remember, but I remember the.
Because I mean, the defense attorney was very clear, about what was going on, without getting into like too many details. But I mean, the defense attorney said what the defense attorney said. All right, so this is tangentially related to the case, obviously. So this was filed in the Eastern District of Kentucky, Pikeville Division. The plaintiffs are Sabrina Atkins, the woman whose voice we just heard on that recording, and another plaintiff named Jennifer Hill. The defendants are Ben Fields, who is now in prison. He was tried and convicted on criminal charges relating to these things that he was doing as a sheriff's deputy. The question is not whether he was doing it. The question is whether or not Mullins was doing it as well.
Or if others knew about it too. And I can't remember, was he, I think he pled out, right?
I think he did plead out. Yeah. So also named as defendants are Eastern Kentucky Correctional Services and Mickey Stines, Lecter County Sheriff. So here comes the plaintiffs, Atkins and Hill, by and through counsel, for their second amended complaint. And they state as follows: it's a civil action for damages for violations of the constitutional rights of the plaintiffs by the defendants acting under color of state law. In addition, the plaintiffs allege that the defendants are liable under state law. Plaintiffs assert that defendant Ben Fields, in his individual and official capacities, violated the plaintiffs' rights secured by the 4th and 14th Amendments to the United States Constitution by subjecting plaintiffs to arbitrary action, unreasonable search and seizure, and deprivation of liberty. The plaintiffs also allege that defendant Fields is liable under state law damages for false imprisonment, assault and battery, malicious prosecution, IIED, which is intentional infliction of emotional distress, negligence, and gross negligence. Defendant Eastern Kentucky Correctional and defendant Lecter County Sheriff Stines are alleged to be liable to the plaintiffs for deliberate indifference in failing to adequately train and supervise defendant Fields, and for state law violations related to failure to supervise and train defendant Fields. Jurisdiction and venue. Excuse me. The court has original jurisdiction. Do you explain jurisdiction in federal courts real quickly, babe?
So there's different ways that you can get jurisdiction, including like diversity, meaning you live in different states, but this is going to be based on the fact that they're suing a government entity. So you can't just go into federal court just because you want to. You have to qualify.
Right. Like things like diversity jurisdiction. There's different ways to do it. All right. So parties: Sabrina is a resident of Pike County. Jennifer is a resident of Perry County. So you have two different counties there.
Yeah, but this is because they're suing the governmental entity.
Correct. So defendant Fields was at all times relevant to this complaint, acting as Lecter County Sheriff or Deputy Sheriff. Fields is sued in his official capacity on the declaratory relief and damages and in his individual capacity as to all claims set forth herein. Upon information and belief, defendant Fields is a resident of Lecter County, Kentucky. At all times relevant here too, defendant Fields was acting under color of state law in performing the acts or omissions complained of in this complaint. So defendant EKCS, which is the correction system, is a for-profit Kentucky corporation engaged in the business of providing pretrial ankle monitoring services in Lecter County, Kentucky, and qualifies as a state actor acting under color of state law. Stines is the duly elected Lecter County Sheriff, elected pursuant to the Kentucky Constitution. And Stines was also acting under color of state law and performing the acts or omissions complained of in the complaint. So these are the factual allegations related to Sabrina. So she was arrested in Lecter County, Kentucky in April of 2021. From April 21 through June 2nd of 2021, Sabrina was incarcerated in Lecter County Jail. She obviously could not make bond. In early June of 2021, she was released from the Lecter County Jail and placed on home incarceration. Defendant Fields, so she finally made bond. Defendant Fields, a deputy sheriff at the Lecter County's Sheriff's Department, was assigned to be Sabrina's home incarceration officer. It's a scary thought. After she was released, Sabrina had a difficult time finding housing accommodations in Lecter County. Fields was aware of Sabrina's housing issues as well as Sabrina's domestic issues. Fields visited Sabrina in the evening, the night that she was released from the Lecter County Jail, to bring her cigs and to, quote, console her, end quote. At this time, Sabrina notified defendant Fields that she did not have the money to pay for her ankle bracelet, but she was terrified to return to the Lecter County Jail. Defendant Fields made some flirtatious comments about Sabrina's looks and body and told her that he was confident that they could, quote, work something out, end quote. Sabrina understood these communications to mean that she would receive favorable treatment from defendant Fields if she provided him with sexual favors. Thereafter, Sabrina and defendant Fields communicated on a regular basis by text messages. In late June of 2021, Fields asked Sabrina to meet him at the Electric County Courthouse in the evening after dark. Defendant Fields took Sabrina into District Judge Mullins' chambers, telling Sabrina that he wanted to meet her there because there were no cameras. Oops. At this time, Fields took off Sabrina's ankle monitor and told her that she would not have to pay the associated fees any longer, but could remain out on home incarceration. I mean, that right there. Okay. That right there. So this is pre-trial. Okay. Which means that typically every 30 days or so, Sabrina is going to be in that courtroom in front of Judge Mullins. Judge Mullins is going to be asking about if there are any violations, if she's still wearing her bracelet, all like those questions just come up when you have somebody that's out on home detention.
Or the prosecutor's asking it to make sure.
For sure.
Right.
For sure. I mean, I've had judges ask it all the time. So, I mean, it's strange to me that this guy felt comfortable enough to go into a judge's chambers and then felt like he had the ability to be able to take this bracelet off without anyone that's court ordered.
And that's why the Kentucky, the company that does, if the correctional service oversees the monitoring, that's why they're in it, because that thing gets reported right. That would otherwise in the normal course be reported right away.
If you tamper with it, let alone take it off, if you even tamper with it, like they tell you, don't take a shower, don't use alcohol around. Like there's all these different, like rubbing alcohol. There's all kinds of different things that will set that thing off. They're hypersensitive. There's no way they didn't know that this thing had been removed. Now,
yes, Travis, that's accurate. I was going to explain that when we got to the 1983 claim, but that is the suing a government entity for violating your federal rights under Section 1983 gets jurisdiction.
So between late June and December of 2021, Fields met Sabrina at the Electric County Courthouse in the evening or early morning hours approximately 6 times. During these meetings, Fields' behavior escalated from flirtatious comments to forcible kissing to oral sex to intercourse with Sabrina, all of which occurred at the Electric County Courthouse after hours in Judge Mullins' chambers.
And I would just say, if Judge Mullins was involved in this, he probably would have let somebody know that they had cameras in the courtroom. I mean, in his chambers.
Maybe. You would think.
I just don't think that's going to pan out, but let's keep going.
Sabrina was coerced and compelled to comply with defendant Fields' advances given defendant Fields' position of power, and because she could not afford to pay for the ankle monitor and did not want to return to the jail. Sabrina did not consent to the sexual abuse. These meetings would typically occur the night before Sabrina had a court appearance. And Fields would put Sabrina's, here's our answer, would put her ankle monitor back on and otherwise fix it so that she would appear compliant with her home incarceration the following day. Upon information and belief in December of 21, certain persons at the Electric County Courthouse were notified that defendant Fields was having inappropriate communications and or relations with Sabrina and were provided text messages evidencing the inappropriate communications and relations. Upon information and belief, defendant Fields became aware of the information contained in the preceding paragraph. In late December of 21, Fields stopped communicating with Sabrina by text message or otherwise. Upon information and belief, in early January of 2022, Fields filed a complaint against Sabrina, claiming that she was not complying with the terms of her home incarceration. Upon information and belief, this complaint was filed maliciously by the defendant in an effort to punish Sabrina and in an attempt to save his own job and reputation. Sabrina was arrested on January 26th of 2022 in Pike County. Sabrina was terrified that she would be transferred to the Lecter County Jail, where upon information and belief, defendant Fields' wife is employed as an officer. Oof. And where upon information and belief, defendant Fields was previously employed. Sabrina had and continues to have serious concerns for her safety and welfare if she were to be transferred to the Lecter County Jail. As a direct and proximate cause of the defendant's actions, Sabrina has suffered and continues to suffer emotional distress, pain and suffering, and mental anguish. Factual background related to Jennifer. So this is the second plaintiff. He was arrested in Lecter County in 2019 and incarcerated at the Lecter County Jail. Lecter County Jail is housed below the Lecter County Courthouse in the same building. In approximately August of 2020, Jennifer was put on home incarceration and to be supervised by Fields. When Jennifer was first notified that she'd be let out on home incarceration, Fields took Jennifer to a small room in the Lecter County Jail to put her ankle monitor on. At this time, Fields told Jennifer if she could not afford to pay the home incarceration fees, they could work something out. When Jennifer asked Fields for clarification, he told her that if Jennifer would do him a favor, he would do her a favor. Jennifer understood Fields to be asking for sex in exchange for waiver of home incarceration fees. Jennifer told him no, that she was not interested. Pass. That's a hard pass there, Deputy Fields. That's a hard pass. Fields had previously gone to Jennifer's home to install a box, which at that time was necessary for home incarceration, and further verified that the home was satisfactory and otherwise complied with home incarceration requirements. 3 days later, Fields shows up at Jennifer's home and arrests her purportedly because her home was not properly maintained for home incarceration. This was pretext. Upon information and belief, Jennifer was arrested because she refused to comply with Fields' request for sex. Jennifer was finally released from custody sometime later that year. On or about August 17th of 2021, Jennifer was again arrested in Lecter County, and soon thereafter, she was bonded out of jail on the condition she would comply with home incarceration. Fields came to the Lecter County Jail to put the ankle monitor on Jennifer. Within a few days, Fields shows up at her home with the sheriff, Mickey Stines, other law enforcement officers, and an ambulance, and claimed that they were responding to a report that Jennifer had overdosed. This was false. Jennifer was in the process of unloading groceries from the car when these individuals arrived. Upon information and belief, this report and visit were orchestrated by defendant Fields in an attempt to intimidate and harass Jennifer. Fields stayed at Jennifer's home after all other law enforcement and emergency services left and threatened to take Jennifer in for a drug screen in a further attempt to intimidate and harass Jennifer. The next day, Fields returned to Jennifer's home and parked his Lecter County Sheriff's Department vehicle behind her house where it was hidden from passerby. Jesus, this guy's like Ray Liotta in that one movie. What the hell was that movie? You remember that movie? Ray Liotta was a cop. Somebody will remember it in here. Defendant Fields knocked on Jennifer's door and instructed Jennifer that if she did not do as he said, he would put her back in jail. Fields told Jennifer that if she made him happy, he would make her happy. He further told her that if he was not happy, neither of them would be happy. Jennifer understood him to mean that if she did not do as he instructed, he would make sure she ended up back in jail as he had done the prior year. Defendant Fields then commanded Jennifer to come outside and to get in front of the front seat of the vehicle, which she did. Fields then got in the front seat of the vehicle and also told Jennifer that he wanted oral sex. Jennifer involuntarily complied with defendant Fields' instruction. Thereafter, Fields offered to pay Jennifer's home incarceration fees. Jennifer's fiance assisted her with these payments, and she did not want him to find out about her interactions with Fields, so she said no. Fields then notified Jennifer that he would be back in a couple of days, and he left. Jennifer told a friend and a roommate about what occurred, but she did not tell her fiance about defendant Fields at the time. Approximately 3 days later, Fields returns to Jennifer's home and in a similar fashion instructed her to have sexual intercourse with him in the back seat of the Lecter County Sheriff's Department vehicle he was driving. Jennifer involuntarily complied with defendant Fields' instruction.
I would have had my video camera, hit cell phone, whatever, ready for that I'm going to show back up in 3 days.
No, that's one, but there's also one with Ray Liotta where Ray just like went insane. Unless Ray's in that one. Somebody will remember it. There were 2 additional times in the weeks and months that followed that when Fields similarly came to Jennifer's home and instructed her to have sexual intercourse with them in the back seat of his Letcher County Sheriff's Department vehicle. Jesus, what a scumbag. Oh my God. Jennifer involuntarily complied with his instruction on these occasions also. Jennifer told her roommate and a friend about these additional instances of sexual abuse and or about the date that they occurred. Each time the defendant Fields came to Jennifer's house for sex, he was wearing his Letcher County Sheriff's Department uniform, driving his Letcher County Sheriff's Department vehicle. Each time defendant Fields came to Jennifer's house for sex, he reminded her that she needed to keep him happy, and that he could have her arrested and put in jail, where he would make her life miserable. Jennifer was coerced and compelled to comply with defendant Fields' instructions, given defendant Fields' position of power over her. Jennifer did not consent to this essay. On or about October 21, Fields came to her home again and demanded sex. Jennifer told Fields that she could not have sex with him, telling him that her fiance was on the way home. On the same occasion, she had asked Fields if she could go visit her newborn granddaughter in London, Kentucky. Fields agreed and removed her ankle monitor so she could make the trip. Upon information and belief, Fields then reported that Jennifer had violated a condition of her bond and she was arrested. At the time she was arrested, Jennifer's belongings, including her cell phone, were confiscated. Jennifer remained incarcerated in Letcher County Jail from October 21 through December 17th of 21. Within the first couple of days after her arrest, in the presence of Deputy Sheriff Whitaker, Fields told Jennifer to, quote, "Remember what I told you and to keep your mouth shut." On approximately 3 occasions, Fields and his wife, Angie Fields, who worked at the Letcher County Jail, removed Jennifer from her cell in an attempt to gain information regarding other inmates. Jesus Christ. Upon information and belief, the actions described in the 2 preceding paragraphs were done to harass and intimidate Jennifer. In December 20 of 2021, Jennifer was released from the county jail on the condition that she would participate in drug court. When Jennifer was leaving the Letcher County Jail, all of her belongings were returned to her except her cell phone, which had mysteriously disappeared. Upon information and belief, Fields or persons working on his behalf took Jennifer's cell phone because there were incriminating communications between Jennifer and Fields on her phone. Upon information and belief, Fields' sister Holly works for the Letcher County Drug Court program. Wow, this shit is incestuous as hell. So he's cheating on his wife, who is, good God. All right, so after being released in the presence of Jennifer's fiance, Fields notified Jennifer that his sister Holly had just notified defendant Fields that Jennifer would soon be arrested due to a warrant from another county. During the same conversation, Fields told Jennifer that she needed to run to avoid arrest, and she did. On December 17th of 2021, a warrant was issued for Jennifer's arrest for a purported drug court violation. On or about February 4th, Jennifer was arrested in Perry County, Kentucky, at the Kentucky Revenue Regional Jail on a drug court violation. She is terrified. Jennifer is terrified that she'll be returned to the Letcher County Jail, where, upon information and belief, defendant Fields' wife remains employed. As a direct and proximate result of the defendant's actions, Jennifer has suffered and continues to suffer emotional distress, pain and suffering, and mental anguish. Upon information and belief, defendant Stines recommended Fields to defendant EKCS for employment. Upon information and belief, EKCS hired Fields in 2020 to oversee the home incarceration ankle monitoring program in Letcher County for them. So upon information and belief, EKCS failed to provide defendant Fields with any significant training related to his position. Upon information and belief, EKCS failed to create and check safeguards to ensure that defendant Fields was providing accurate and truthful information about persons within Letcher County, Kentucky, who were ordered to be put on home incarceration. Defendant EKCS knew or should have known that Fields worked as an Electric County deputy sheriff and regularly performed services for defendant EKCS while wearing his Electric County Sheriff's Department uniform and driving his Electric County Sheriff's Department vehicle. Upon information and belief, Fields inaccurately notified defendant EKCS that Sabrina had been taken off house arrest sometime in the fall of 2021. Defendant EKCS knew or should have known that its home incarceration program was rife for abuse and was intended, it was indeed being abused by defendant Fields. Upon information and belief in December of 2021, Fields, as well as numerous other persons who work at the Electric County Jail, the Electric County Courthouse, and the Electric County Sheriff's Department were aware that Sabrina had made allegations against defendant Fields as described above. So upon information and belief, a complaint was made by the friend of Sabrina Atkins to persons working in the Electric County Drug Court program about sexual harassment and abuse by defendant Fields against Sabrina. The complaint either provided copies of inappropriate text messages between defendant Fields and Sabrina or notified such persons that text messages existed. Fields and other Electric County deputy sheriffs were aware of these allegations relating to Sabrina in early of December of 2021. Stines knew or should have known about these allegations related to Sabrina on or before early December of 2021. These allegations were not appropriately investigated by Sheriff Stines. In early December of 21, Jennifer's fiance called the Electric County Sheriff's Department to complain about defendant Fields. During this call, Jennifer's fiance spoke to a female Electric County Sheriff's deputy and notified her that defendant Fields had been sexually harassing Jennifer. The female Electric County Sheriff's deputy hung up on Jennifer's fiance. On December 15th of 2021, Jennifer's fiance went to the Electric County Sheriff's Department in person to make a complaint against defendant Fields. Jennifer's fiance spoke to the Electric County Deputy Sheriff Whitaker. Wow, that's a fucking mouthful. Who told him that the complaint would be investigated and he needed to keep quiet about this while it was investigated. Very soon after leaving the Sheriff's Department, Jennifer's fiance was pulled over in a vehicle by Electric County Sheriff Deputy Sheriff Norris, who was accompanied by a female deputy. Deputy Norris asked Jennifer's fiance what the fuck he thought he was doing and told him that he needed to keep his fucking nose out of the Sheriff's Department's business. Later that same day, Jennifer's fiance was pulled over again by a man who refused to identify himself by name and who was driving a red Silverado truck, wore a badge, and was carrying a gun. The individual identified himself as being, quote, from the Sheriff's Department and told Jennifer's fiance that he had, quote, stuck his nose where it don't belong and called him a liar. This individual also told Jennifer's fiance that defendant Fields was involved with people who are high up on the ladder and who he should not mess with. This individual further threatened Jennifer's fiance and his family and told him to forget about his complaint and about defendant Fields. During this time that the individual was detaining and threatening Jennifer's fiance, he was speaking to other unknown persons on his cell phone and on a radio in his truck. Upon information and belief, this individual was speaking to other persons employed by the Electric County Sheriff's Department. A couple of hours later, Jennifer's fiance was stopped for a third time by another Electric County Sheriff's deputy driving his official vehicle. This deputy notified Jennifer's fiance that there had been a lot of, quote, chatter about defendant Fields and his complaint that day. This deputy then told Jennifer's fiance that they didn't need any trouble like this in the Electric County Sheriff's Department because they were all barely getting paid as it was. Wow. This deputy was also speaking to someone on his cell phone and radio during this exchange. Upon information and belief, the above-mentioned communications to Jennifer's fiance were aimed at intimidating, harassing, and silencing Jennifer. You think? That's crazy. Upon information and belief, the Electric County Sheriff's Department failed to reasonably investigate the allegations related to Jennifer. Upon information and belief, the Electric County Sheriff and unknown supervisors of defendant Fields failed to adequately train and supervise Fields and other Electric County Sheriff Department employees. The Electric County Sheriff knew or should have known that defendant Fields was sexually abusing females, including plaintiffs, in his charge. Other persons employed by the Electric County Sheriff's Department have harassed and intimidated persons associated with Sabrina and Jennifer in an attempt to discourage other women from coming forward to disparage Sabrina and Jennifer. Defendant Stines did not timely or reasonably respond to reports or suspicions of sexual abuse perpetrated by defendant Fields. The defendant's conduct described as above caused severe injuries to the plaintiffs, for which they are entitled to recover actual damages in an amount to be determined at trial.
So I don't think it's up to you if you want to. It's not that much longer, but the counts I reread them all. They're just like the law. They're not stating any new facts. I would just maybe read the
Here,
caption.
you read them. You read. I'll scroll as you're reading.
All right. So wait, so count 1 is against defendant Fields for violation of plaintiff's rights secured by the United States Constitution and the Fourth Amendment. So you can just go down to the second one.
Wait, you don't even want to read the
No, I'm just saying I don't think like none of it is putting forth new facts. It's just saying that all the things that it said
But
before.
don't they lay out what you need to prove in order to?
Yeah,
to
go ahead. Read them all then.
No, I was asking you to read them. And I'll
Okay.
scroll.
Defendant
So that
Fields.
way you can skip whatever you want.
Well, I'm not going to skip anything then because it's just the law and it's very short. So go ahead. All right. Defendant Fields knowingly and recklessly engaged in the above described sexual abuse of plaintiffs, and such contact was objectively unreasonable. Defendant Fields' sexual abuse of plaintiffs was not rationally related to any legitimate government purpose or otherwise was otherwise excessive. Plaintiffs did not consent to the physical contact with defendant Fields. Plaintiffs were coerced by defendant Fields, and to the extent they complied with the defendant Fields' physical contact, they did so only because they were intimidated by defendant Fields, who provided plaintiffs with privileges in exchange for sexual favors. The above described actions of defendant Fields constitutes a violation of plaintiff's right to be free from unreasonable search and seizure secured by the United States Constitution Amendment 4, which is actionable pursuant to 14 U.S.C. Section 1983. 42 U.S.C., sorry.
Yeah.
Plaintiffs are entitled to recover compensatory damages against defendant Fields in an amount sufficient to fully compensate them for damages they suffered as a result of these constitutional violations. I'll add the S. Defendant Fields willfully, wantonly, recklessly, and maliciously engaged in the unconstitutional conduct described above. Plaintiffs are entitled to recover punitive damages against defendant Fields in an amount sufficient to punish said defendant Fields, as well as deter him and others similarly situated from committing such violations in the future. Before we go on to count 2, I'll just note, you may have noticed in here, sometimes they say things like upon information and belief, while other times they don't. So that is to convey direct personal knowledge, something that happened that you were a part of, and then they use upon information and belief for things like, upon information and belief, this was done to threaten and intimidate her, because they're not in that person's mind. So that's why you're hearing a difference in language depending on what's being alleged. There was something else I was going to mention that I just forgot. So count 2 is against defendant Fields again for violation of the 14th Amendment. They incorporate everything above. Plaintiff has a fundamental liberty right to personal security and bodily integrity, extending specifically to the right to be free from sexual abuse. And now I will pause because I remember what I was going to say. So you may be wondering, like, well, why are they suing under the 4th Amendment? Why are they suing under the 14th Amendment? Like, why don't they just sue for sexual assault? This is how they get under the 1983. It's a violation of your federal rights. And then you can also, once you have sufficient federal jurisdiction by asserting a federal offense, a violation of your federal rights by government under color of law, then you can also raise state claims. So more like an assault claim. So that's why you're seeing violations of the 4th Amendment and violations of the 14th Amendment, because you're probably thinking, well, yeah, sounds like well beyond a violation of the right to be free from unreasonable search and seizure. But that's why they've got to do that to get it into the federal jurisdiction. So Proceeding on, Defendant Fields sexually abused plaintiff in violation of this fundamental right. Defendant Fields' conduct was so oppressive it shocks the conscience. Defendant Fields' conduct was intended to injure plaintiff in a way unjustifiable by any government interest. The above described action of Defendant Fields constitutes a violation of plaintiff's substantive due process rights secured by the United States Constitution Amendments 14, which is actionable pursuant to 14 U.S.C. 1983. Plaintiffs are entitled to recover, keep scrolling, compensatory damages against Defendant Fields in an amount sufficient to fully compensate for damages they suffered as a result of the constitutional violation. The Defendant Fields willfully, wantonly, recklessly, and maliciously engaged in the unconstitutional conduct described above. Plaintiffs are entitled to recover punitive damages to punish. Go ahead, babe.
Oh, sorry.
So count 3 is deliberate indifference, failure to supervise and train, also under 14 U.S.C. 1983 against the sheriff, so that's Stines, and against the correctional center. So Defendant Fields was inadequately trained in the area of proper supervision and interaction with female criminal defendants on home incarceration. So I just want to say that it's hard sometimes, and this was able to survive, but to you know, to get in these other entities when you're dealing with intentional crimes that they could not have anticipated, but they've alleged enough facts here that people knew and didn't act quickly enough. So that's why they're able to bring this against the sheriff and the correctional center. The defendant, Letcher County Sheriff, and and the correctional center knew or should have known the Defendant Fields was abusing his power and taking advantage of females on home incarceration under his control and supervision. The inadequate training of home incarceration officers employed by the Letcher, is it Letcher?
I say Lecter.
Okay, Lecter County
but
Sheriff's.
I butcher shit all the time, so I could be completely wrong.
Lecter County Sheriff's Department and the Correctional Office is likely to result in the ongoing violation of constitutional rights. The Lecter County Sheriff's Department and EKCF policymakers have been deliberately indifferent to this need for adequate training. The failure to adequately train, supervise, or discipline their employees by the Lecter County Sheriff's Department and EKCS proximately caused the violation of plaintiffs' constitutional rights. The acts and omissions. All right, go on. I really think we can skip the rest of this. It's starting to get boring.
Okay.
What does anyone else think? Should we keep going? Because it's all just, I think we just let them know what the claim is. And so now count 4 is negligence, gross negligence, assault, and battery. And this claim is just against Fields. So again, they incorporate everything. And they say Fields had a duty to reasonably supervise plaintiffs while they were on home incarceration, that he violated that duty, that his violation of duty was directly and proximately caused her injuries. She's entitled to recovery because of that. He acted willfully and wantonly, and she's entitled to punitive damages. Next. Count 5, gross negligence, infliction of emotional distress against Fields. So again, what they're doing in each of these counts is just saying the words that get every element of the offense. So that's why they kind of do it this way. So they indicate that as a direct and proximate result of the above described grossly negligent conduct, the plaintiffs suffered and continue to suffer severe emotional distress. Plaintiffs are entitled to recover compensatory damages, and they are entitled to punitive damages because he was grossly negligent. Next. Count 6, intentional infliction of emotional distress against Defendant Fields. Wait, wasn't that what count?
No, that was
4 was?
That was NEID, negligent.
Negligent. Oh, okay. So this is intentional infliction. So again, they say the same things here, but here's the key: for intentional infliction of emotional distress as opposed to negligent infliction, they have to establish what's outlined here in this very first allegation. The above described actions of Defendant Fields were intentional and are outrageous and offend generally accepted community standards of decency and morality. So then they go on to say that she suffered severe emotional distress as a result. She's entitled to compensatory as well as punitive damages since they were willfully, wantonly, recklessly, and maliciously engaged in the conduct alleged. So now you've got count 7, negligent retention, training, and supervision against just the correctional center. And they outline that the correctional center employed Fields to implement the home incarceration program with all responsibilities attendant to said position as a law enforcement officer. They outlined that they had a duty to exercise care over his hiring and training, that they breached that duty of care to supervise him, in that they were negligent and careless, or grossly negligent in the training of him as a home incarceration officer, and that they knew or should have known he had engaged, upon information and belief, in conduct similar to that in which plaintiffs were subjected as alleged herein, and posed an unreasonable risk to females similarly situated. Then they say they failed to adequately train him. As a direct and proximate and foreseeable result of that, she's sustained damages, including mental, emotional, and that they are entitled to punitive damages as a result. You want me to read the wherefore? So wherefore clause, to an award of compensatory damages against defendants in an amount sufficient to compensate the plaintiffs for injuries, an award of compensatory damages against defendants in an amount sufficient to compensate plaintiffs for damages they suffered as a result of the above described bases for liability under state law. So the first was under federal, the next is under state. Award punitive damages, award plaintiffs costs incurred in prosecuting, including attorney's fees and expert fees, and any other relief the court deems fit, and they demand a jury trial.
Yep. So, I mean, it's insane. Like, that whole thing is insane. That case. So as you can see, it's definitely, it's collateral, but it's very much a part of, or could very much be a part of what's going on with Stines.
But
I mean, like,
it might
all this
not
shit
be.
was happening.
It seems like Stines may have been having his own marital and family issues at the time. So
maybe.
we'll have to see how it.
I mean, just to be clear, this suit is ongoing. Like, this isn't a suit that was filed and has been settled yet. It's still very much in the process.
Are starting settlement conferences, or should be, next month. So we'll have to see if it settles, and if it does, we'll try to get the plaintiffs on here. We'll see what we can do.
These suits, in addition to the Attorney General of Kentucky started an investigation as well. And the last time this thing was up in court, counsel for Stines was trying to have those investigation records turned over for in discovery, because, I mean, look, let's be honest, Allison, like, if you and I were handling this case, we'd absolutely be digging into all of this shit. All of it. I mean.
Yep. Do you want me to pull up the indictment?
Of
Fields?
who's, yeah, you could pull up his indictment if you want. I'm going to see if, Donna's case is, like, if that was up and it's happened. I don't imagine it's going to be a long appearance there, but we'll see.
Okay, yeah, you do that while I do this then. So this is Ben Fields. This is his indictment. He was charged with RAPE in the 3rd degree, 2 counts, Class D felony, 1 to 5 years in prison, carries a fine of $1,000 to $10,000. He's charged with sodomy in the 3rd degree, 2 counts, Class D felony, 1 to 5 years in prison, tampering with a prisoner monitoring device, 3 counts, Class D felony, 1 to 5 years in prison. Isn't it shocking that tampering with your monitoring device is the same level of felony of the first 2? Because typically those are charged against the the defendant in a case. So,
It is shocking.
and then perjury in the second degree, 1 count, a Class A misdemeanor, up to 12 months. Perjury as an official misdemeanor. All right. So on or about, for count 1, they allege that on or about July 21st through January 22nd in Lecter County, Kentucky, the above named defendant, Ben Fields, committed the offense of RA in the 3rd degree when, as a deputy sheriff and or employee of a company under contract regarding the Lecter County Jail, he subjected a person, number 1, whom he knew was in custody and or home incarceration, to sexual intercourse. Count 3, that on or about August 21st through December 21st in Lecter County, Kentucky, the above named defendant, Ben Fields, committed the offense of RA in the 3rd degree when, as a deputy sheriff or an employee of a company under contract with the Lecter County Jail, he subjected person number 2, whom he knew was in custody and or on home incarceration, to sexual intercourse. Sodomy in the 3rd degree. And when this says number 1, you can assume that that's the same number 1 as in count 1. So it's also between July 21st and January 22nd, he committed the offense of sodomy against victim number 1. And count 4, between August 21st and August 2021 and December of 21, he committed the offense of sodomy against person number 2. Then he tampered with the prisoner monitoring device. Again, same dates for number 1, July 2021 through January 2022. When he intentionally disabled, deactivated, removed, or tampered with a device used to facilitate electronic monitoring of person number 1, who had been ordered to wear the device's condition of pretrial release. Tampering with regard to number 2, it has the exact same allegations, but it is occurred between August 2021 and December of 2021. You've got a person 3 that on or about July 21st through July of 2021 through October of 21 in Lecter County, Kentucky, Ben Fields tampered with the prisoner's monitoring device, and this is of person number 3. So now that's the only the 3rd person. And then perjury, that on or about January 14th of 2022, Ben Fields committed the offense of perjury in the 2nd degree when he made a material false statement which he did not believe in subscribed written instrument for which an oath is required or authorized by law, to wit, a criminal complaint with the intent to mislead a public servant in the performance of his or her official functions. So that's saying he lied in a criminal complaint. And he did plead guilty. And do I remember what he got? Do you remember what he got? It's in here somewhere in all these documents that I've gathered. Do you remember, babe?
What he ended up getting nailed on?
Yeah, well, how much
What he
time?
pled out to?
Yeah.
I don't remember
All right, let me
offhand.
look at his docket from August 31st. Let's see. Oh, I also have his discovery and inventory, which is kind of interesting. It actually gives 4 people's names. So maybe person number 1 for sodomy and person number 2 for sodomy are males. They've got different initials. So I won't pull it up for you. The only thing, there was a grand jury proceeding on September 29th of 2022. And then what they have here are jail records and then court records of someone whose initials are BC. So that would not be the one of the 2 defendants in the. My computer closed down. Do you remember what were the 2? I know one's Sabrina, and what's the other person's name?
Jennifer Hill.
Okay, so court records for BC. Court
Wait.
records.
YB is saying he only got 6 months. Really?
Was that it? No.
Yeah. So 6 months and 5.5 years. Wow. Talk
That's
about a
outrageous.
sweetheart deal. Wow.
All right. So anyway, the records are belong to an individual named B, whose initials are BC. Then you've got the court records of SA, that's Sabrina. Then you got the court records of JH, that's Jennifer. And then you have the court records of CT. So now that leads me to believe, as I said, that person number 1 for sexual intercourse and person number 2 were different than the sodomy people, because you've got 4 initials here for the discovery. And then let me see what else I have for Fields. I think I've got his docket. I just don't know. Yeah, jury trial was scheduled. There was a pretrial conference. And then it says a mediation was scheduled. Then they did his arraignment. Maybe this is not the latest criminal docket that we had. Let me just check this. No, this is the same. Okay. All right, that's all we've got for that.
Okay. So, yeah, I mean, to me, I think it's going to be a fascinating trial, and like shit's going to come out. What it's going to be, I don't know. Whether it's a bunch of red herrings, maybe. If it was Judge Kevin Mullins was the victim of Mickey Stines.
And Kevin Mullins is listed as a witness, is listed as a person with information. So the defendants had to file disclosures, and one of the first disclosures is the name, and if known, the address and telephone number of each individual likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claim or defenses, unless the use would be solely for impeachment. And they listed Stines about having information about his employment, but they listed a Deputy Whitaker as an individual who may have knowledge regarding the allegations in plaintiff's complaint. I should check and see if they were required to amend this disclosure to be more specific. But they indicate Kevin Mullins, and all it says is District Judge of Lecter County, Kentucky, without any information. They list the former plaintiff's Atkins' former attorney. They list a Commonwealth attorney, Edison Banks. Then they list some people from the correction services, and they identified documents. So they do admit that there were text messages produced by Sabrina, and then other records that are, in the possession of the correction services without saying what they were. So
yeah, I mean, it's like the fact that he got 6 months is unbelievable to me. Talking about, somebody put it to the Good Old Boy Network is alive and well in Kentucky. There's no question about that. And as far as, like you hear it from us all the time, like there are very few people on the planet that have more power than people with guns and badges. They just have an awful lot of power, and you can see it on full display in the allegations contained in that particular complaint, because you've got these women who are, just country gals, probably ran into a little trouble. I don't know what the charges were. I wouldn't be shocked if they were drug related, whatever the case may be. And, they don't have money, and, they're just being completely abused by this cop who's using his station and his authority to force them into having sex with them and performing sexual favors. It's like, it's disgusting. It's terrifying. It's so scary. And like, to give a 6-month slap on the wrist is like, it just shows you, you know, like that prosecutor, how does that prosecutor walk to these two women and say, hey, we're going to make an offer. We're going to make a plea offer. We're only going to make him do 6 months, which theoretically, I don't know if that's a straight 6 or if he's going to do day for day. I have no idea. I would hope at the very least it's a straight 6, but I mean, but don't worry, he's going to be on probation for 5.5 years. I mean, how are you feeling if you're Sabrina and Jennifer Hill? You know, I mean, seriously, that is just unbelievable. It's unbelievable. And like, imagine how much guts it had to take and bravery to come forward knowing that this is the kind of shit that they pull.
And that so many higher, like, people of authority are involved. You could have gotten screwed.
Could have gotten killed easily.
Yeah.
Easily. Like, I mean, you don't think that's going through her mind? I mean, man, it's unbelievable. So yeah, to me, it's all intertwined. This Steins case is going to be one to watch for certain. So we will definitely be watching it very, very carefully. It's probably one, Kentucky's not all that far. That's one I can make a drive for. Oh, good. Thank you, Oasis. Donna's hearing is over. Next hearing, February. Did they stream it? I wasn't seeing it. I was looking for it. I didn't see any of the usual suspects. I did not check any of Florida's news channels to see if they were covering it. That's typically who has it covered, but I'm imagining it wasn't too eventful. And then I think we're going to end it. I'm going to pull up one more that we're going to dip back over to Luigi Mangione. I'm going to just throw in the last couple of updates. These are the latest developments here. Let's go through them real quick. These are per the New York Times. And they're saying a suspect charged in the New York assassination saw the killing as a symbolic takedown, according to an internal police report that detailed parts of the 3-page manifesto found with him at the time of arrest. He's been charged with second-degree murder, the forgery, and 3 gun charges. An extradition hearing for Mangione took place today at the Blair County Courthouse. Mr. Mangione arrived and struggled against officers as they led him towards a courthouse entrance before he disappeared into the building, and he turned towards reporters and shouted, which we watched. In the courtroom, his lawyer, Thomas Dickey, so he was represented. For those of you, I saw you in the chat, and I appreciate it, because you're right. He absolutely had to be represented at that hearing. So he was. His lawyer, Thomas Dickey, told the judge that his client is not agreeing to be extradited to New York. He is contesting it, Mr. Dickey said. In New York, the internal police report, which was obtained by the New York Times, said that his manifesto also indicated that he saw the killing as a direct challenge to the healthcare industry's alleged corruption and power games. Frankly, these parasites simply had it coming, the manifesto was quoted as saying. The internal report added that the suspect, quote, likely views himself as a hero of sorts who has finally decided to act upon such injustices. And he expressed concern that others might see him as a martyr and an example to follow. So he was arrested, as we know, in the McDonald's. So then this is what so this is some of the stuff. He had a privileged upbringing. Mr. Mangione grew up in Maryland, attended high school at the Gilman School in Baltimore, which we watched during our live, his valedictorian speech, where he was an athlete and the valedictorian of his class in 2016. Graduated from the University of Pennsylvania with a bachelor's and a master's in engineering 4 years later. social media accounts and other websites offer a glimpse into his background in the technology and video games industry and his curiosity about self-improvement. Oh, there's one new update. In emails from Japan, the suspect talked politics and philosophy. Wow. Okay. He was in Dr. Bogle's Substack in early April. This guy shared some of his correspondence. There was a 2-hour video call, a dozen emails. They agreed on some things. Both men leaned toward the political left on some issues and aligned with the right on others. For example, he said Mangione supported equality of opportunity, but doubted the efficacy of identity politics. Overall, the impression I got of him, besides his curiosity and kindness, was a deep concern for the future of humanity and a determination to improve himself in the world. They also talked about a post Mr. Bogle had written about gamification and about the motives of Ted Kaczynski, the so-called Unabomber. Luigi disapproved of his actions, but was fascinated by his ideology and shared his concerns about rampant consumerism, gradually eroding our agency and alienating us from ourselves. In our last exchange, a direct message on social media on June 10, Mr. Mangione asked Mr. Bogle for help curating his social media feeds. I forgot to get back to him. Oh, if only we'd have done that, maybe this wouldn't have happened. Maybe if he could have just been on his socials and gotten a real big following. He's got a big following now, all over the place. Huge followings. Bogle was bewildered. He was so thoughtful and soft-spoken that he seemed like the last person I'd suspect of murdering someone. So there you go. So I think that's all the updates that we wanted to handle today. Hopefully we gave you up on
I just want to
Stines.
thank Lisa Loney for her generosity, and wasn't surprised by the Steins Fields debacle.
Oh,
Fiasco.
yeah. No, I mean, it is not. Is it Loney or Looney?
It's 1-0.
Oh, so yeah, that would be Loney. Okay. All right. You guys rock. Let's see. Did you go through the
I did.
papers and stuff? Okay.
I didn't. Thanks Tiffany Knox, who became a member, and Lemonade Kale. I guess we're her favorite couple. Or
Aw.
his.
Appreciate that.
Yeah, thanks. And I did the rest. Yep.
All right, you guys. We love you. We love our community. Make sure that you're sharing, liking, subscribing, doing all the things that help us get out to the world. I think we're still at 35,000. I think we're at 35.3, so we're growing
I
nicely.
don't get it. Should be 300,000 as far as I'm concerned. Stick an O on it. Stick an O on it.
I agree, babe. I agree.
And I
babe.
don't get it.
We'll get there. We'll get there. It's a process. It's a process. It's all about the algorithm. That's why I'm constantly begging people
All
to
about the algorithm.
share, like, subscribe. Share, like, subscribe. And if you're a replay crew, make sure you leave a comment. That really helps get it out there. If there's action in there, YouTube's like, oh, people must be interested about this. Let's push it out there. So they push it out there. So, all right. We love you guys. Thank you. Because without you, I'm just an old man
Talking about a lot of cases.